All right, Lauren Moraine here, back with you to talk some more about copyright law. We did an introductory video on just an overview of copyright. But what I've decided to do this semester is to actually do a video each time we complete a week in our copyright law class, just to kind of recap what we've gone through over the course of the week. And each time you'll see we might repeat some things, but there are different levels of depth that we'll go to each time we get into a particular subject matter. So, having completed now the first week and a half of copyright law class for the semester, here are some of the things that we have discussed. First of all, copyright law is one of the three major sections of what we call intellectual property law. Intellectual property law includes patents, copyrights, and trademarks. Now, each of these things cover a different area of IP. For example, patents will cover inventions and sophisticated formulas and machinery and that sort of thing. There's a certain level of novelty and originality that's required, a very high level, for patent protection. Then you have trademarks, which cover such things as logos and company names and slogans and that sort of thing. And then you have copyrights, which is the subject of our class. And copyrights cover the original writings of an author. So that's where we start as we start our discussion here with what we covered over these first three classes, or the first week and a half of the semester. Original writings of an author. Now, for it to be copyrightable, it must be independently created. So we need independent creation. We also need fixation in a tangible medium of expression. We'll talk a little bit more about that as we move along. And there must be copyrightable subject matter. The copyright statute, section 102 of 17 USC, talks about copyrightable subject matter. And so we will have a number of things that we can protect by copyright, such as books and plays and music and choreography, etc. All of those things are copyrightable subject matter. Now, once you create a copyright, you have the opportunity to keep it for your exclusive use, which, of course, generally will not create any monetary value for you. But you can also license it to others to use to generate income, the monetization, so to speak. That is usually done by the way of a copyright transfer. You can transfer, we talked in our previous video about the Section 106 bundle of rights. Copyright transfer can be of any or all of those Section 106 rights. And that transfer can be done via an exclusive or a non-exclusive transfer. If you're transferring it exclusively, then that must be done in writing, okay? So exclusive transfers must be done in writing. Non-exclusive may be done orally without a signed writing. Of course, if you transfer the work, there may be a time when you want to terminate that transfer, and sometimes that's by operation of the contract itself, and other times it's by operation of law. If it's by operation of law, then the statute will tell you when you can actually terminate a transfer. We'll just briefly touch on this week because we get much deeper into terminations later on in the semester. But just suffice to know that under the 1976 Act, you can terminate a copyright of transfer 35 years after the date of the transfer. There's some nuances in there. There's a 5-year window. There's some notice requirements and so on. But we will talk about that when we get to our termination discussion later on in the semester. Now, if you have a copyright, obviously, the hope is that you'll be able to do something with it, generate some income from it, and get some value out of that work. You also have the right to prevent others from using the work. That's your exclusivity right. Now, there will be times when someone will make a use of a work that they don't have the right to use. In that case, they trigger a cause of action, i.e., a copyright infringement action. And in order for there to be a copyright infringement, you have to start off with a couple of basic things. You have to have ownership of a valid copyright. Then there must be an unlawful copying on the defendant's part of copyrightable or original elements. And there must be substantial similarity between the two works. If you have those in place, and provided that you have registered the copyright, you can now have a cause of action for copyright infringement. That whole registration thing is something we'll be talking about throughout the semester as well, because there are some key touchstones that you need to be aware of as a student, or as a creative, or as a company owner, or somebody who has any kind of interest in copyrightable works. Now, our copyright laws are governed by a federal statute. The first one that we had in this country was the Copyright Act of 1790. At that time, it covered maps and charts because that's pretty much all we had. And over the course of the years, different things were added. Photography was added, musical performances and sound recordings, and et cetera. Each time new technology was advanced, the act was amended. In 1909, there was a major new Copyright Act, which changed a few things, including the term for copyright protection. And then in 1976, we had our latest major Copyright Act that was written. For the purposes of modern understanding of copyright, it's important for you to have a grasp of both the 1909 Act and the 1976 Act. And that, of course, is because there are still songs that exist today that are copyrighted and protected under the 1909 statute. The major differences between the 1909 and 76 statute, there were a number of differences, but the two main ones I want you to focus on at this stage of the course: the term for copyright protection and the formalities that were necessary in order for copyright to subsist. Now, with regard to the formalities, under the 1909 Act, there were three basic formalities that had to be in place in order for a copyright to exist. Copyright had to be registered with the Copyright Office. There had to be a general publication of the copyrighted work. And third, there had to be notice on the copyrighted work. Copyright year, the name of the claimant, that's what notice was. Those three things were required for copyright, for the clock to start on copyright under the 1909 Act. And that clock, the term, was for a period of 28 years of protection, with the option of going back for a renewal term for 28 more years. Now, that 28 plus 28, which is 56 years, was amended in 1962 to be 28 plus 47. They added 19 more years onto it in 1962. So 28 plus 47. And then in 1998, another amendment came along, the Sonny Bono Copyright Term Extension Act, which added 20 years to all copyrighted works. That included 1909 Act works that were still protected by copyright. So at that time, it became 28 plus 67. So that means the maximum number of years that a 1909 Act work could possibly be protected is 95 years. Now, the 1976 Act comes along, enacted, signed into law in 1976, and then it became effective January 1st, 1978. And the two major changes with regard to term and formality were as follows. The copyright term was no longer for a finite number of years. It was defined by the life of the author plus 50 years. Now that became life plus 70, and it's retroactive to all 76 Act works. So 76 Act work, someone that you know, an artist, a writer, a poet, a songwriter, has created a work, say in 1990. If that person died in the year 2000, the copyright would expire in 2070, 70 years after their death. The other thing that is important to know is that the formalities that had been required under the 1909 Act were no longer required under the 76 Act. All you need for a copyright under the 76 Act is fixation in a tangible medium of expression. Fixation. So that could be something as simple as writing it out on paper. That could be recording it on a video or on a sound recording or on a digital file. Anything that could allow this work to then be perceived by the human eye or ear, or with the aid of some device or machinery, that would be considered fixation. Mind you, we're going to get deeper later on in the semester, but I just want to put this on your ear right now, and that is, it is still beneficial and still advisable for copyright owners who are exploiting their works in the public sphere to register their works. It's still beneficial, and there are a number of reasons why it's beneficial. And in fact, it's required before you sue. So that's another piece that you should keep in mind there. Now, authorship. When you talk about authorship and the definition of authorship under copyright, it must be authored by human hands. So authorship is a human characteristic. It cannot be a garden that is authored by the birds and the bees who pollinate the flowers in a certain way. It can't be authored by a monkey who grabs someone's camera at a zoo and starts randomly taking pictures. That would not be copyrightable because it has to be copyrighted by a human being. Copyright Act says that there is an author is defined as one to whom anything owes its origination. One to whom anything owes its origination. So the person who created this thing is the author. Now, copyright is, of course, an intangible thing. What we mean by that is we talk about intellectual property. It's something that comes out of your head. It's an idea. And unlike, a shoe or a book or a jacket or a house where you can actually look and touch and feel this thing in a tangible manner, these ideas are intangible. So one of the things that the law does to kind of put some parameters around this thing is we have a fixation requirement. Fixation. The requirement that the work be fixed actually kind of puts a house around it, puts some fencing around it. So you now have something that's not just an amorphous thing that is floating out there, but you have something that you can point to as being a thing, right? Now, as for the requirement of creativity, under copyright law, all you need is a minimal degree of originality and creativity. It's a very low bar because we are not in the business of valuing copyrightable works. Oh, that's good because it's sophisticated, or that's bad because it's simple. We don't do that. As long as the work has a sufficient minimal amount of originality, then that work, provided that is covered by Section 102 copyrightable subject matter, that work will be available for copyright. The purpose of the work is totally irrelevant. We don't care what it's for. If it's original and independently created and it falls under that Section 102 copyrightable subject matter, then you can have a copyright. Independent creation is the key. And what I mean by that is it's possible for two different individuals to independently create works that are substantially similar. Depending on how sophisticated the works are, it's more or less likely that could even happen. But technically, it is possible for two different individuals to independently create a similar work. And if that's the case, then each of those individuals would have the rights to the copyright in their independently created work. Obviously, one of the examples that I use in class is when you talk about the sophistication of, say, a jazz piece or a classical piece, it's highly unlikely that two individuals would both independently come up with a very sophisticated jazz piece or a very sophisticated classical piece. But popular music, by definition, is simple and accessible. And because of that, it is a lot more likely that maybe a chord progression used in pop music might be a similar one to someone who independently created it otherwise. The fact that you have additional elements such as melody and rhythm and lyrics are where you get that divide, and you can really see whether or not somebody has created something independently in the pop music world. All right, so what else did we learn over the last week and a half? A valid copyright. If you have a valid copyright and there's unlawful copying of that work, unlawful copying of original elements, or unlawful copying of copyrightable elements, then you have the workings of a cause of action for copyright infringement. But there must be substantial similarity between the works. We'll talk a lot more about that as the semester progresses. We also talked this week a little bit about photography. We'll get much deeper into that throughout the semester, but on the front end, these first three classes, we did touch on photographers having choices they make with regard to the rendition of the photograph, the timing of the photograph, the creation of the subject. All of these things are elements of choice that the photographer makes that renders the photographer an author, right? We're going to take these pictures at this time of day, at this location, wearing these items, with lighting set up in this way, filtering set up this way. We want you to pose leaning that way. We want your hand, this hand over the other hand. All of those things are choices the photographer makes, and thus the photographer is an author. Now, don't worry. Even if you don't make all those choices, even if all you do is take out your iPhone and click a picture, that was a choice you made to take that picture at that time, at that place. So there would be authorship and thus a copyright ownership in that particular photograph. We also talked about a little bit about compilations and derivative works, what they are, how they're created, what they have in common, and how they're dissimilar. Compilations and derivative works are both based upon pre-existing material. But the major differences are these. A compilation can be based on copyrightable or uncopyrightable material, whereas a derivative work must be based on copyrightable material. So, compilation, a collection of things that you put together into a new collection, can be of songs. Maybe you have a greatest hits recording of songs that were already copyrighted on different projects. Or maybe you have a movie soundtrack with a bunch of songs from different artists who have already been copyrighted and recorded elsewhere. That would be a compilation of copyrightable and copyrighted material. But you could also have a compilation of facts. For example, the names of all the capitals in the United States would be factual information. But the way that you collect it, but the way that you actually express it could render that to be original enough for you to get a copyright in the compilation. Derivative work, on the other hand, must be created based on a copyrightable work, such as a song or a book or a story or a play or whatever. And more than trivial changes are being made to this work to create a derivative work. We learned in our first video that Section 106 exclusive rights include the right to create derivative works. That, of course, means that if I make a derivative work based on a copyrighted work, I have to get the permission of the current copyright owner in order to use that work commercially. If, on the other hand, I'm making a derivative based on a work that is no longer protected by copyright, then I'm okay. I don't need to get the permission because that work is not any longer protected by copyright. Merely trivial variations will not support copyrightability in the case of a derivative work. It's merely trivial as far as your changes. And that typically is what happens if you're making a cover song. Cover songs are not derivative works because they're only trivial changes that are being made. So they are covers. That there's a separate exception under the statute that allows you to make cover songs once the song has already been released and recorded. We'll cover that later on in the semester. And then finally, the last thing that we covered this week was an actor and an actor's right to own copyright in their performance in a show or a film or any kind of production. And the short answer is they do not have ownership in copyright for their performance in the film. And furthermore, the fact that they have performed in the film gives the film director, the producer, filmmaker, the right, the implied license to use their performance in the film. If the law instead had said that every performer in a film context has a copyright in their performance, we would have chaos. We would have films that copyrights were split in thousands of pieces because of all the different elements. So copyright in your performance does not exist for someone who plays a role in a show or a film. And that was about it. That's what we covered this first week and a half. We'll continue to do this the rest of the semester. And we look forward to seeing you along the way, and leave any comments or ask any questions you'd like to have answered, and I will answer them. Even beyond the scope of the class that I'm teaching, I'm happy to talk to you and answer any questions you might have about copyright law. All right. Take care until next time.